as I say, other political parties have worked in the same direction and introduce the same type of proposal. I'm sure it would get a unanimous support here in the House, and I look forward to being passed speedily, Minister.
Senator van Turnhout.
Thank you very much, and welcome back, Minister, to the House, and welcome for this legislation that we're dealing with today. It's now 5 years since the publication of the Law and Reforms Commission in 2007, as you said so yourself, Minister. And my understanding is that Ireland is the only remaining jurisdiction in the European Union and one of the very few in the Council of Europe area without a spent conviction scheme for adult offenders. And I think this is regrettable given the negative and far-reaching consequences the present system has for ex-offenders, their families and for society in the long run. The vast majority of convictions passed by Irish courts are for minor and non-violent offences which incur short-term prison sentences, fines or community-based sanctions. Yet, in the absence of a spent convictions regime, these individuals face serious restrictions and barriers in employment, training, education, travel, taking out an insurance, therefore buying their own home, and setting up bank accounts and many other areas of their lives. Their family members are also directly impacted. I know of a woman who has encountered serious difficulty securing house insurance because her son, who has a criminal conviction, is actually living in the family home. And I heard a story recently of the devastating consequences of a non-expungible criminal conviction by the Irish Penal Reform Trust, and they've named the person in this story, Siobhan, who said, "I shoplifted a bar of chocolate and was caught by shop security. I was so afraid I could not tell my name. I've never been in trouble as a kid. If a teacher gave out to me, I cried, and the thought of being in trouble with the law scared me to pieces. Security said if I didn't cooperate, they would call the guards. I didn't, and so they did. I was arrested and I appeared in court. I ended up with a €20 fine for theft. I felt this has impacted me beyond belief. It was 7 years ago, and I still feel as bad as I did then. When it may seem small in the wider world of criminal justice, this offence has affected me tremendously. I was excluded from working with a community project for refugee women that I was interested in becoming involved in because of it, not to mention the many care assistant jobs I couldn't apply for as the recruiter was seeking to only hire somebody with a clean record. I made a mistake and no one is more sorry than me. The stigma has sometimes led to my feeling deeply distressed and unable to cope. Expungement would grant me the self-forgiveness I would need to move on with my life. I'm not a bad person, just someone who, because of a lack of support coping abilities at a hard time in her life, lost her way. It makes me sad because our system, by not having spent sentences, does not recognise change and so is not really rehabilitative in the way it claims to be. And I think, Minister, that's the very type of stories that we're trying to get at with this bill. The current situation does not allow Siobhan and the thousands of others in her shoes to wipe the slate clean, and neither is it just or equitable. Furthermore, by hindering the rehabilitation and reintegration back into society for those who've served custodial sentences, we're creating a recipe for reoffending. If our system doesn't allow for individuals to put their past behind them, what incentive is actually there for them to do so? Therefore, I very much welcome the introduction of the bill. It's long overdue. I welcome the fact that this bill has positively built upon the proposals contained in the Law Reform Commission report in 2007 by raising the maximum limit from 6 months to 12 months imprisonment and by shortening the conviction period of 5 to 7 years down to 3 to 7 years. In my view, the original proposals were far too conservative and restrictive. However, I am concerned that the new proposals don't go far enough to deliver on the main purpose of the bill, which is set out in the explanatory memorandum, as being to assist the rehabilitation of offenders who often experience difficulty securing employment as a result of having a conviction. Minister, I note with considerable interest the recent developments in the UK spent convictions arrangements, and a review of the Rehabilitation of Offenders Act 1974 by the Ministry of Justice in 2011 judged the limit of 30 months sentences to be too restrictive. And in response, the UK Government, through the Legal Aid Sentencing and Punishment of Offenders Act 2012, has reformed the relevant sections of the Rehabilitation of Offenders Act by setting the limit at 48 months. This is 4 times the limit that we're proposing in this bill. The UK has had a 40-year head start on us with spent convictions legislation. And during this time, the Ministry for Justice has strived to strike the appropriate balance between public safety and reducing barriers to reintegration for those who have moved on from offending behaviour. And I think we have an opportunity here to capitalise on what the UK has learned. I also note that in the UK legislation, the conviction-free or rehabilitative period is at the lowest end of the offending scale is 2 years. And I think this seems sensible, given that the Home Office research into reconviction rates suggests that if an individual has not offended in the first 2 years, they're at equal risk of future offending as someone without any previous conviction. And the length of time required for rehabilitation must be proportionate to the seriousness of the offence committed, but it should not be so long as to constitute an additional and disproportionate punishment, nor should it discourage ex-offenders from moving on from their offending behaviour. I do think there is merit in the calls for a hybrid model, whereby anti-discrimination provisions are incorporated into the bill. And I know this is the model of incorporation adopted in many Australian and Canadian territories and is recommended in the current bills in New Zealand. The personal testimonies from ex-offenders I have read are irrefutable evidence of discrimination in employment, education and in access to goods and services on the basis of a criminal conviction. And I do believe that this discrimination must be addressed in some forms, and I think what we're doing here today is a good and strong start. Minister, I've listened very closely to what you've said, and I'm going to take some time between this and our next stage, a committee stage, to consider my position with respect to the blanket exclusion of certain categories of employment, in particular to those working with children, and how that interacts with the National Vetting Bureau Bill. And I will come back at committee stage with amendments if I see they're warranted. Thank you.
Senator Hayden.